Im Namen des Volkes. Erstens.
The Federal Constitutional Court, the guardian of the Constitution.
Absatz 1 in Verbindung mit Artikel 2 Absatz 2 Satz 1 des Grundgesetzes unvereinbar.
Discover landmark decisions of the Federal Constitutional Court. The Federal Constitutional Court is the guardian of the fundamental rights. All citizens of the Federal Republic of Germany who believe that their rights have been violated by public authority may lodge a complaint with the Federal Constitutional Court. Apart from major constitutional issues, the Federal Constitutional Court also decides everyday matters, such as feeding pigeons in public places and riding on forest trails. In 2010, the so-called Hartz-IV Act raises the issue of a minimum existence. What means does a human being need for a life in dignity? This touches upon the most important sentence of the Basic Law. Human dignity is inviolable. The Federal Constitutional Court decides that the calculation methods of social benefits applicable at the time
are incompatible with Article 1, Section 1 of the Basic Law, in conjunction with the principle of the social welfare state contained in Article 20, Section 1 of the Basic Law.
The court did not criticize the amount of the benefits as such. It held, however, that the standard benefits had not been determined in a transparent and realistic manner. The judgment particularly focuses on the needs of children. Originally, their benefits were derived by way of generalization from the standard rate of an adult. But children are no small adults, as the court held. Since then, their benefits are calculated according to their own child-specific needs. The Federal Constitutional Court acts as an arbitrator between constitutional organs. If there is a conflict between two state organs, the justices of the Federal Constitutional Court decide on their mutual rights and obligations. In 1994, the Federal Constitutional Court rendered a landmark decision. It examined whether Parliament must be consulted before a deployment of armed Bundeswehr forces abroad. The federal government had decided to deploy troops abroad without prior approval of the Bundestag. The justices of the Federal Constitutional Court emphasized the character of the Bundeswehr as an army of Parliament.
Das Grundgesetz verpflichtet die Bundesregierung für einen Einsatz bewaffneter Streitkräfte, die grundsätzlich vorherige konstitutive Zustimmung des Deutschen Bundestags einzuholen.
Thus, the Federal Constitutional Court confirms momentous political decisions about deployments of the Bundeswehr abroad must be taken by representatives of the people, by the Bundestag. Through its jurisprudence, the Federal Constitutional Court strengthens the democratic culture of the Federal Republic of Germany. Free public discussion is made possible by the fundamental rights of freedom of assembly and freedom of expression, which are enshrined in the Basic Law. In several decisions, the Federal Constitutional Court has therefore strengthened these fundamental rights, which are essential to democracy. When construction work for the nuclear power plant in Brockdorf, Schleswig-Holstein starts in 1976, this meets with increasing resistance among the population. Even after some years, protest does not subside.
Herr Polizeirat Wösner, all die Demonstranten, die dort sitzen, haben beschlossen, gewaltfrei und friedlich Widerstand zu leisten.
When, in February 1981, more than 50,000 people are expected at a demonstration, the district commissioner bans all assemblies in an area of 210 square kilometers. The demonstrators lodge a constitutional complaint with the Federal Constitutional Court, which is granted. The right to assemble freely with others without any special permission has always been a
sign of the freedom, independence, and empowerment of self-confident citizens.
This decision of the Federal Constitutional Court provides German authorities with guidelines on how to deal with assemblies, particularly with mass demonstrations, in the future. And it strengthens the citizens' right to freely and jointly express their opinions. Society is in permanent change. This has been taken into account in the jurisprudence of the Federal Constitutional Court. The Basic Law guarantees equal rights for men and women. However, it takes years to implement this concept. In 1958, the German Civil Code still stipulates,
if the parents are unable to agree in matters concerning the child, the father shall decide. The father is entitled to represent the child.
The Federal Constitutional Court declares both provisions to be incompatible with the Basic Law, and thus renders equal rights for men and women effective in practice. The Federal Constitutional Court has to decide controversial issues even in times of heated discussions in society. In 1975 and in 1993, it rendered two major decisions about the protection of unborn life.
Paragraph 218a Absatz 1 des Strafgesetzbuches in der Fassung des Schwangeren- und Familienhütegesetzes ist insoweit mit Artikel 1 Absatz 1 in Verbindung mit Artikel 2 Absatz 2 Satz 1 des Grundgesetzes unvereinbar.
The legislation on abortion that was enacted as a consequence has been in force since then. The Federal Constitutional Court acts as an interpreter of the Basic Law that is in line with the requirements of a modern society. As a consequence of the Civil Partnership Act adopted in 2001, the Federal Constitutional Court ensures equal treatment of civil partnership and marriage. Security and freedom of the citizens, two legal interests the state must protect. The threat posed by terrorism has increased the need for security worldwide. In order to counter the threats, the legislature reacted with numerous interferences with the freedom of its citizens. The citizens, in turn, stood up for themselves, raised the issues before the Federal Constitutional Court, and repeatedly achieved amendments of the statutes in question. Through their judgments, the justices of the Federal Constitutional Court have prevented an excessive collection of personal data and recently protected privacy of computer users. The Federal Constitutional Court derives from the Constitution that the development of one's personality, which encompasses the citizen's private sphere, is generally protected. The general right of personality guarantees the citizens the confidentiality of their data and protects them from being spied on by the state, especially if this happens clandestinely. In 2014, the Court of Justice of the European Union transfers this principle to the European level. Since then, the following applies Europe-wide: no storage of data without effective data and personality protection. With an interpretation of the Basic Law that is open to political, economic and social changes, the Federal Constitutional Court defends the citizens' fundamental rights in the 21st century as it has before.